Last week, the U.S. Supreme Court made several rulings that would have riveted the attention of the nation if we had not been preoccupied with COVID-19, protests against police brutality, rioting, tearing down statues. Shall I go on? Well, the rulings, nevertheless, were big deals. One ruling recast the 1964 Civil Rights Act so that it encompassed identification as gay or transgender, and there was more. The court also rescued DACA from President Trump's executive order, declined to take a case that could have reinforced Second Amendment rights, I think, and a case that could have addressed the court-created monstrosity of qualified immunity. There's a disturbing thread that runs through these cases and others. What is it? We'll find out in today's Lighthouse briefing from the Independent Institute. So today we're going to explore those questions that I mentioned with our invited guest, William Watkins, Jr. Welcome, Bill. Glad to have you.
Good to be here today. Thank you, Graham.
It's a pleasure. And I think you're coming to us from South Carolina, if I'm not mistaken.
You are correct.
Okay. So Bill Watkins has served as a prosecutor and defense lawyer. He is a research fellow here at the Independent Institute. He's published a bunch of books, several of them with us here at the Independent Institute. I want to make sure you're aware of those. There's this great book, Reclaiming the American Revolution, which is about the Kentucky and Virginia resolutions. Well, very much worth reading. This wonderful book that I'm especially fond of called Crossroads for Liberty, Rediscovering the Anti-Federalist Roots of the Constitution. A lot of people forget that there was a whole other group of people at the time of the founding who had other views than the Federalists and actually did have an influence on how the outcome was formed. And more recently, we've just published this wonderful book, In All Fairness, which you probably have seen before. In this one, there's this great chapter by Bill Watkins called The Retreat from Equality Before the Law, which is a very important subject. This morning, we have just published your latest piece, Bill, on our Beacon website on dishonest interpretation about these cases that we're going to be discussing today. So I encourage everybody to visit our website, independent.org. You can read the latest published work by Bill Watkins. But again, we're very, very glad to have you. And this article has been titled Dishonest Interpretation. You deal with a variety of issues and cases, but maybe we should start with the one that would have been the marquee on the news last week if there weren't so many distractions, the Bostock case. So what's that all about? Please help us to understand that.
Well, essentially, the case was a matter of statutory interpretation on whether Title VII of the Civil Rights Act of 1964, which in part bans employment discrimination based on sex as well as race, national origin, religion, etc., but whether sex, as indicated in the statute, prohibits discrimination based on sexual orientation. So that's the issue that the court was asked to address.
What's amazing about the decision is that it was, what was it, a 6-3 decision, I think?
6-3 decision.
Yeah, and the way these things work, I think, is that the Chief Justice can decide who's going to write the decision unless he's in the minority, right? So he chose Justice Gorsuch.
That's right. Justice Gorsuch is the author of this opinion, joined in by the Chief Justice and what we would loosely call the liberal wing of the court.
Yeah, pretty fascinating coalition. And so Justice Gorsuch's opinion seems to have to do with a really heretofore unimagined interpretation of the word sex in the statute. How did he do that?
Well, he tried to portray himself as essentially following Justice Scalia's textualism. Justice Alito called him out nicely, I thought, and said, this ship sails under the flag of textualism, but it is really a pirate ship
Wow.
without a proper flag. So I liked that. But he starts off with, and let's look at the basic principles of statutory interpretation.
Right, yeah, that's
it's the court's job to give the intention that the legislature would want. And how does it do that? Well, firstly, it looks at the words of the statute and gives them their plain, ordinary meaning as they would have been understood in 1964 by the public. Mm-hmm. The court then even admits that the public would have understood that to mean sex, to mean a biological male, biological female. Mm-hmm. So far, so good. But then it makes a leap later on in the opinion to say, that if you're discriminating, if you fire someone, let's say because they're homosexual or lesbian, you have discriminated based on that individual's sex. And that logic, that conclusion just does not follow. That is not logical reasoning.
Yeah, besides which, typically in cases like that, I mean, I'm not saying that I would advocate this, but when somebody does fire an employee on that basis, it's not usually because they identify with the label. It's because of some action or behavior that manifests in the workplace that they somehow don't think fits their workplace. So it's action, not identity, and yet the court's focusing on identity and saying that this has to do with their being. Well, what's weird, I'm having trouble getting my head around this, Bill. The court is not departing from original intent textualism, according to Justice Gorsuch.
According to Justice Gorsuch, they're not. But that's, as Justice Scalia would say, jiggery-pokery. That's balderdash. That's foolish. It's obvious to anyone, if you look at the word sex, what it meant in 1964, biological male, biological female. If an employer fires someone because of their sexual orientation, he is engaging in sexual orientation discrimination, not sex discrimination.
Right.
It's two different categories. Congress has certainly passed many statutes that specifically prohibit sexual orientation discrimination in addition to sex discrimination. The first 30 Court of Appeals judges that interpreted sex understood it this old-fashioned way, if you will. But the court believes it knows better and claimed to be exercising textualism when it was really amending a statute.
I wonder if the other members of the winning coalition of votes on the court, aside from Roberts and Gorsuch, really embraced the textualism, which was allegedly the basis of Gorsuch's opinion. What do you think? I
would seriously doubt that. I would see that they got a result that they liked, and they would put their name on any piece of paper that got them there.
Well, that's what's troubling about this. I mean, there's lots of disagreement about, what does it mean to identify as gay or to identify as transgender and so forth. And I don't think we need to adjudicate that socially right now here. But even those who like the outcome, which I guess is greater protection in the workplace for people who identify as such, even people who like that outcome should probably be a little uncomfortable with the procedure, the way the outcome was gotten to. And why is that?
Really, that's the big question here. Who is to decide? Who is to decide this type of issue? Should it be the Congress, a policy-making body? Should it be the courts? I say it ought to be Congress. This is a policy decision. Congress, the Senate has passed a bill before. The House has passed a bill before that would add sexual orientation discrimination to Title VII. They just haven't gotten together at the same time and presented that to the president. Right. Or do we want six unelected lawyers making national policy? That's sort of scary to me insofar as, at least with Congress, in theory, you can go the polls, I can go the polls, and we can throw them out, or at least try.
Right. No
vote on the court. They are above any sort of censure by the public that way. So that's what's troubling.
There was a kind of remarkable disregard for the intent of the statutory framers here of the Civil Rights Act. In fact, the court, as you said a moment ago, I think, explicitly set aside their intent, saying that, they couldn't have intended this when they used the word sex. This reminds me of other cases where, legislative intent was just set aside. So I'm just cycling back in my mind of, 8 years when Obamacare was established, by a thread of a vote in the Congress and then signed by President Obama. And as I recall, it was litigated because the Obamacare statute required people to pay a penalty if they didn't get the requisite insurance. So they were penalized for not buying that product, that insurance product, or some insurance product. And that was alleged to be unconstitutional. And the court, as I recall at that time, it disregarded legislative intent then too, because as I recall the case, and please correct me when I stop talking here, correct me if I get this wrong, Bill, but as I recall, it had been said by the sponsors of the legislation at the time that this is not a tax. We are not raising taxes. This is not a tax. But Chief Justice Roberts, when he rescued Obamacare, said that the court can creatively attribute an intention to Congress which it did not actually have. And he said it was a tax, and therefore Congress has the power to tax per Article 1 of the Constitution, and so therefore Obama stood. Blatant disregard for legislative intent, but I got the outcome. Am I seeing a thread here?
No, you're absolutely, Graham, seeing a thread. Is Roberts, it seems, is not above trying to be an institutionalist. He wants history to remember him as a great Chief Justice that did not play favorites, that was not ideological, and therefore we see some very strange decisions that he signs off on. The Obamacare decision being the most obvious example. Is it a tax? Is it a penalty? The word says penalty. Everyone else says penalty, but we hold it that it's a tax. Here we go again with this in our case that we're talking about today, sex. Everybody in 1964, and frankly today, knows what Congress meant and what we mean when we talk about
the court says
sex.
that they know what Congress meant, right?
Exactly.
But that's a kind of honesty, at least. There's a kind of candor in that reasoning, which I find refreshing, even though I find the outcome disturbing.
No, could be part of what we used to call the greenhouse effect when Linda Greenhouse was at the New York Times. Supposedly conservative or Republican-appointed judges or justices want that approval, want that pat on the back from at cocktail parties and such from the movers and the shakers, and I'm sure Roberts is getting that.
I'm thinking also about the announcement last week, also from the court. I don't know what the legal status of it was, but the upshot was that President Trump wanted to scuttle DACA, and it had been established by President Obama's executive order, but President Trump was going to get rid of it by an executive order, and the court said no. And didn't it find kind of an ingenious way to save DACA from President Trump?
No, you're absolutely right.
What was it
essentially,
exactly?
Everyone would agree, any serious legal scholar, that Obama's executive order, the administrative law that was made, was done improperly. There were no findings. There were no review and comment period. It's illegal. So Trump's people rescind an illegal measure by a memo, just as Obama had drafted. But the court says they have to jump through all these hoops in the Administrative Procedures Act, which Obama didn't jump through.
Right.
And therefore, even though it's an illegal statute, they have to keep or not statute, but a rule, they have to keep enforcing it because they didn't jump through the proper loopholes. So could conceivably be around for the rest of Trump's term and following.
I recall the other day reading the original memo from then Attorney General Jeff Sessions, which was giving the rationale for the executive order. And it looked pretty complete to me. What was wrong with it, I wonder?
What's wrong with it is the court didn't like the result. There's a lot of political pressure because we're dealing, of course, with young people who were brought to the United States before they had a say in the matter and have been here a good while. And I think there's again, back to policy, there's a policy idea that they ought to receive some sort of status or be helped out to allowed to stay. I'm sympathetic to that argument personally. I just don't understand why that should be achieved through an executive order one way or the other way, rather than having Congress face up to its job and amend the relevant laws. No, that's right. And the congressional statutes do not carve out any exceptions for enforcement for these folks, no matter what policy preference we have. And as we just talked about, do we want Congress making that policy, individuals we elect and can have the franchise to vote against or for, or do we want unelected lawyers? It's scary what the court does and the policy it makes.
Yeah, because really it's a question of what does self-government mean? We have constitutional self-government, and we have structured it in a certain way with the separation of powers, and the court has a role, the legislature has a role, the president has a role. But when we step out of that form of self-government, we're not really self-governing anymore. We're sort of choosing people indirectly, and then they get to ignore all the rest of it when it seems to suit them. This is very troubling, especially ironic when Justice Roberts likes to be portrayed as what he calls an institutionalist somehow.
No, that's correct. This not only focuses the problem of the court taking center stage in policy, but as well as the problem of the administrative state, which really makes most of our laws these days rather than Congress, the managerial class, which, of course, is another discussion maybe for another day.
Yeah, it is. Unfortunately, it's all related. As to the court itself, it used to be, I don't know, let's say 30 years ago, a lot of sort of jurisprudentially conservative people would say, oh, well, we've got to have judicial restraint rather than judicial activism. And, I'm not sure that bright line really tells us much these days. It seems that you can, in the Obamacare case, for instance, it was presented as a form of judicial restraint, namely deference to Congress against Congress's own words, and everything got turned upside down. Probably the most important principle here is that courts need to exercise their function rather than the function of Congress.
No, that's right. I always go back to one of my favorite descriptions that Thomas Jefferson gave about what a judge should be. And Jefferson said, quote, a mere machine, end quote.
Wow.
They should not be making policy. They should not be stepping out of the judicial role of adjudicating cases and deciding what is reasonable, what's a good decision, what's a bad decision. Actually, of course, in the 1770s and 80s, it was not judges that decide on constitutionality, but juries of the vicarage. That was the people. Yet judges relish that role these days.
And this question, it sort of like expresses, I guess, a misunderstanding that ordinary people have. But okay, here's the question. Isn't it true that in our system of judicial supremacy, the court has a lawmaking function? Like ordinary citizens, I get this, like people say to me, yeah, well, law comes from courts. So courts make law. So what's wrong with that, Bill?
I think the assumption, which most academics and most lawyers would have as well, that we do have a system of judicial supremacy, or we're supposed to have one. We do have one, unfortunately.
Yeah, de facto.
I agree with the doctrine of judicial review. I think that's congruent with Jefferson's tripartite theory of constitutional interpretation, that both all three, the legislative, executive, and the judiciary, as agents of the people, can interpret law, but there is no supreme being amongst them that rises above the others, though today in our system, it is the court. The court is the final word, is the final authority. Once it speaks, we're to shut up. And that was never the intent of the framers.
Yeah, as I recall, in the famous decision that upheld slave recovery laws, President Lincoln said he disagreed with the Supreme Court, that the Supreme Court had been mistaken in not regarding slaves as people protected. And so that was clear that he wasn't just going to defer to the court. But when this recent decision came down, the Bostock decision, I think the next day President Trump said, well, yeah, that's what the court says. That's the end of the subject. That doesn't sound like a self-governing constitutional republic when the Supreme Court speaks and everybody else shuts up.
No, and unfortunately, it's what an old professor of mine, William Quirk, called the happy convention, is there's a working convention to where the president and Congress are thankful when the court takes these hot button issues away from them, for example, abortion, and they can say, oh, the court's spoken, we can't do anything about that. We don't have to deal with that. And they're sort of,
yeah, exactly.
Glad I don't have to make a decision.
Right, yeah. And of course, the trouble is they really do. They are responsible for their role in the constitutional system. This is part of the beauty of our constitutional structure, that it's participatory and it's structured, and there is a way for making laws and a way for executing them, and they're not the same thing. So we've got to get these things straight. Okay, I've got a bunch of questions here coming in on my chat box, my Q&A line. Hard to know which one to choose. Thank you for sending all these in, friends, and more. Please send in more. Here's one. Okay, very concrete. Does the Bostock case cement the trans people competing in women's sports? Several females are pursuing court correction. It seems they will likely lose because of Bostock. Yeah, can you speculate?
No, that will only bolster the cases of what sex means. That if you're discriminate on account of a person's biological status or otherwise, or what they claim to be now, you wave the Bostock flag, and sure, it's going to be harder for sports conferences to have truly men's and women's sports now.
Right, and you can see the frustration of many women athletes. It used to be that they were competing with one another, but now anyone who decides to switch over is suddenly competing with them, and it doesn't feel like an equitable playing field. It actually doesn't feel like the equal protection of the law, where it's a public institution. And so you can see how many of these athletes are frustrated at this kind of thinking, because it seems to fly in the face of that equality in whose name these decisions are made. Okay, here's another one. Is there any good challenge coming up on Obamacare?
Well, we're going to see a number of decisions soon. There are petitions and cases up seeking yet again to nail the coffin shut, but I'm sure Justice Roberts, he's worked very hard to save that statute, and
oh boy,
look for him to continue to work very hard.
Yeah, I anticipate it too, and of course you can't help but wondering if Justice Gorsuch may join him, if necessary, on that issue. But there's a bunch of other cases coming up. I understand that there's a case on abortion and clinic doctors coming up out of Louisiana, I think, where the lawmaker said that because of the safety issues that the abortion doctors have to have admitting rights at local hospitals. I think that's under contest. That's coming up. And there's the one about whether President Trump has to release his taxes. There's some on religion in schools. It's going to be a hot July, don't you think?
No, we talked about this a little bit earlier, that it's going to be a fun end of the term. It's going to be interesting to see how the majorities line up, since with the Bostock case, we see the 6-3 decision with 2 votes that we typically think would be more toward the conservative side.
Yeah, well, and of course, even to put it that way, it sort of flies in the face of what I think my deeper view is, at least, that there really shouldn't be a conservative or a liberal side. There should be, like Thomas Jefferson said, it should be a machine, namely looking at the principles and the intentions, looking at the case, applying the principles to the case, coming out with the ruling. That's much more mechanical, according to Jefferson, than any kind of conservative versus liberal thing.
No, exactly. They used to call it the T-square approach in the 1930s, that what were derisively known as the 4 horsemen on the Supreme Court.
Right.
But we just look at the constitutional text here, and on this side, we look at the statute, and if it doesn't square, we're done. There's no need to play games or try to resurrect something.
Right. Here's another question I've gotten. Some people say, if you're a classically liberal-oriented voter, does it still make sense to vote for the GOP in order to obtain, what this person calls a conservative, non-activist judiciary? Does that make sense?
Yeah, it makes sense. And as you see, Gorsuch and Roberts seemingly under the influence of the greenhouse effect. If the only reason you're voting a particular way is for judges, yes, one should perhaps have pause when they go into the booth.
Here's another question coming up in the chat box. A person says, but the liberal so-called justices seem to vote in a very partisan fashion. Does that really appear to be the case? And of course, I would say, I'll let you speak to that. My first thought when I read that question is, I have thought so, that the so-called liberal part seem to vote in a more partisan fashion. But now I'm starting to wonder when I see how Gorsuch and Roberts act. The trouble is the partisanship seems to all go in one direction with both the liberal wing and part of the so-called conservative wing. Do the liberals vote in a partisan fashion, or do they sometimes rise above it?
Now, if you see statistics on who joins and what opinion, it's interesting that, for example, Ginsburg and Scalia back in the day were very often aligned on, say,
yes,
non-constitutional big picture issues. Because obviously the court issues a number of opinions, many of them unanimous, many of them 8-1, 7-2, that never make the news. And but it's only when you venture into these hot button policy issues do you really, I think, see some of the true colors emerge. And one team seems to be able to play together coherently, the other one not so much.
Yeah. Okay. So we have someone raising his hand. John, you are permitted to unmute yourself and speak if you would like to. We are ready for your question.
Hi, good afternoon. Just wanted to get back to the DACA ruling. So we had an executive order put it in place that in violation of the APA, and then we have one that repeals it in violation of the APA. What I'm wondering is there any difference between them in the sense of there's been, in the intervening years, reliance that the court looks and says, oh, people have now relied on that.
Yeah, that's a good point,
badly
John.
constructed ruling, so we cannot damage them by repealing it. I mean, is that I admit I have not read the opinion. So was that considered at all?
And by the way, can you tell us, Bill, what APA is that John's referring to?
Oh, it's the Administrative Procedures Act, and he's absolutely right. That factored into the court's decision. It was a big issue that there was no weighing of the justifiable reliance by the dreamers, as they're so called, on the Obama executive order, even though it was illegal. Again, if you want to read a good summary and where the opinion's wrong, read Thomas's dissent. We have an illegal, improper executive order, which was repealed, but the illegal, improper order must stand because certain procedural hoops weren't jumped through, and interest perhaps arose because people relied on an illegal, unconstitutional measure. It seems
reliance. That's John's point. Reliance.
Right. And so anyway, the HHS, everyone is supposed to go back and consider reliance and other factors and weighing whether to get rid of an unconstitutional program.
The trouble with that form of reasoning, that reliance is crucial, that you can't pull the rug out from under people once they've begun to rely on a policy like deferred action enforcement for childhood arrivals. The problem with that is that it seems more equitable to those immediate beneficiaries, but at the same time, if in fact there has been a decision made that's fundamentally unconstitutional, but people come to rely on it, then it just means that if you can get away with a constitutional violation long enough, then it can stay forever, and that can't be a good constitutional principle.
No, and the dissent points out that this will set a precedent where a lame duck president leaving office can sign all sorts of orders, and his successor will not be able to easily get rid of them and establish new policy or a constitutional policy because of decisions like this. It's a good argument.
Very fascinating because, let's say we have another change. Let's say in the very end, just to flip this thing over, the very end, President Trump does a bunch of executive orders that are just a bunch of egregious things. Okay, so then if this way of interpreting the APA, Administrative Procedures Act, is held to, in order to undo them, the new president coming in, let's say it's Joe Biden, will have to have a very comprehensive and ample, justification, rationale, and so forth, way better than Jeff Sessions offered for President Trump to undo DACA. But in the meanwhile, while they're taking all the due diligence and care to formulate that new rationale, a whole bunch of people are starting to rely upon the bad executive orders from President Trump. And so it comes up in a court eventually, and then the court's going to say, or will it? Will the court say, oh, well, yeah, this was regrettable that President Trump did this his last week in office, but lots of people have come to rely on this, so we can't go back now because it would be unfair to those people. Could that be right, Bill?
That's an accurate description of what's happening or could happen. It's not right, but it's, again, another example of you have Congress has taken no legislative action. The president wants to repeal an improper rule that was made by a previous administration, yet the administrative state lives on and continues to implement this illegal program in perpetuity. Sad.
It does often help, I think, to think about putting the shoe on the other foot because, sometimes these things seem partisan, but really everyone is better protected in the long run by the constitutionally established rule of law that is not just a form of social policy making, but actually leaves social policy making to Congress where it belongs. We're all protected by that, not just the right, not just the left. I think a lot of people can come to embrace this recognition of lawfulness if they see that it really, at the end of the day, it's nonpartisan.
So it should be a nonpartisan system there. It should have the courts away from the partisan politics. And again, as we've said, be a machine, do your judicial role.
Yeah. It sounds unflattering. It sounds unflattering to the judges.
Yes, if they want to make policy, they can go run for office, but otherwise,
exactly. Exactly. Okay, so one last question here before we close off because we're coming near the end. But this question really gets to the heart of the matter. And I think you kind of addressed this, but you can kind of summarize by addressing this question, Bill. If Congress fails to act or is slow to act to fix some kind of historic wrong, shouldn't the courts step in and fix that historic wrong?
No, absolutely not, because that interferes with separation of powers principles. All legislative power is with Congress. All executive power is with the president. The judicial power rests with the courts. When we start blurring those lines, again, we have branches that could check one another, taking control of the whole process here. And we go from checks and balances to separations of powers to what John Taylor of Caroline called the supreme apple, is what he called the Supreme Court. Said we have three apples, three departments of government. There is no supreme apple. They're all the same. They're equal, or they should be.
Right. Well, we need to remember that the constitutional system protects all of us in the long run, and if there are historic wrongs, there is a way to fix them. It's not like they have to go and fix. That we build a consensus among citizens, and we elect representatives who will change the law through the established procedures. Let's in fact right our historic wrongs, but let's do it in the right way so we don't cause more damage that we don't really intend. So anyway, with all that said, let me thank William Watkins Jr. for spending this time with us all the way from South Carolina. Let me remind our participants that there's this wonderful book, Crossroads for Liberty, which Bill Watkins has written. I encourage you to take a peek at it and also look at independent.org today under our Beacon site, where you will see his latest article, which he's been discussing in various ways today. Let me thank our supporter for standing with us financially. And of course, I encourage you to go to our webpage, independent.org. Top right, there's a donate button. We'd be very grateful if you continue your support for us as we try and get the word out to protect liberty, individual rights, and the rule of law that applies equally to everybody, respects their dignity. And with that said, Bill Watkins, thank you so much.
Thank you, Graham. Have a great day.
It's a pleasure, and thanks to everybody who joined us today. See you next time.